Supreme Court of India Kuldeep Kumar vs UT Chandigarh and others decided on February 20, 2024 SCC Online SC 175 Facts of the case. The agenda of the meeting was to conduct the election of Mayor, Senior Deputy Mayor, and Deputy Mayor of the corporation, and the elected councillors desirous of contesting the election were called upon to file their nominations for the posts. The appellant in the High Court seeking a direction to the Deputy Commissioner to ensure that free and fair election in a writ petition alleging electoral malpractices by the presiding officer who conducted the election to the post of mayor at the Chandigarh Municipal Corporation. The High Court issued notice and listed the petition after 3 weeks, but it declined to stay the result of the election or grant any other interim relief. The appellant approached this court assailing the order and raised serious allegations about the sanctity of the election. Findings of the court: all the ballot papers contain the name of the appellant in the upper half and the name of the eighth respondent in the lower half. Below the names of the candidates is the signature of the presiding officer. After the ballots are cast, the presiding officer is required to initial each ballot in terms of Regulation 6(11). Each of the ballot papers bears 2 signatures of the presiding officer. It is evident from the physical inspection of the 8 ballots which were treated to be invalid that in each of those cases, the vote was cast by the member in favor of the appellant. The presiding officer has placed a line in ink by way of a mark at the bottom half of each of the ballots which have been treated to be invalid. It is evident that in each of the 8 ballots, the vote had been duly cast in favor of the appellant. Further, the presiding officer has evidently put his own mark on the bottom half of the ballots to create a ground for treating the ballot to have been invalidly cast. In doing so, the presiding officer has clearly acted beyond the terms of his remit under the statutory regulations. Even if the mark which was placed by the presiding officer is taken into consideration, that mark does not create any doubt about the candidate in favor of whom the vote was cast. The vote was cast by placing a rubber stamp on the upper half of the ballot, and hence the ink mark which was placed on the bottom half by the presiding officer would be of no consequence. The ballots had not been defaced when the presiding officer put his mark at the bottom. The ballots left no manner of doubt about the candidate for whom the ballot was cast. But that apart, it is evident that the presiding officer is guilty of a serious misdemeanor in doing what he did in his role and capacity as presiding officer. Firstly, by his conduct, he has unlawfully altered the course of the mayor's election. Secondly, in making a solemn statement before this court on February 19, 2024, the presiding officer has expressed a patent falsehood, despite a prior warning, for which he must be held accountable. The conclusion that the result, which was declared by Shri Anil Masi, the presiding officer, is plainly contrary to law and would have to be set aside. The appellant is reflected to have polled 12 votes. 8 votes cast in favor of the appellant were treated as invalid. As detailed above, each of those 8 invalid votes was in fact validly cast in favor of the appellant. Adding the 8 invalid votes to the 12 votes which the presiding officer recorded to have been polled by the appellant would make his tally 20 votes. The 8th respondent, on the other hand, has polled 16 votes. The appellant, Kuldeep Kumar, is declared to be the validly elected candidate for election as mayor of the Chandigarh Municipal Corporation. We are of the considered view that a fit and proper case is made out for invoking the jurisdiction of this court under Section 340 of the Code of Criminal Procedure 1973 in respect of the conduct of Shri Anil Masi, the presiding officer. The writ petition before the High Court shall stand disposed of in terms of the above direction.